Friends, I am feeling little bit problem in recording the video. I feel my only voice will reach to you. Please bear with me. I am Ashok Arora, advocate practicing at District Court, High Court and Supreme Court of India. I am going to explain one of the most important topic, that is professional misconduct in the legal profession. Friends, we all know legal profession is said to be divine or secret. No doubt, every profession has set of standards for professional conduct that members of that profession must uphold. But there are situations, I am talking about the reality, that professional misconduct occurs frequently in advocacy work as well as in other professions. If we define professional conduct, then we can say that professional misconduct, then we can say that actions which are taken by the individuals which which appears to be inconsistent with his professional ethics and are unsuited for the profession, that is called professional misconduct. If we go by the dictionary meaning, particularly of the Black's dictionary meaning, it gives us a precise definition of the phrase. It says that it is violation of some established and unambiguous rule of action or prohibited act, or we can say to failure to perform a duty, or further we can say that unlawful behavior or improper or wrong behavior. So there is vast definition of professional misconduct. Now coming to our legal misconduct, we have to dive through Advocates Act 1961, as well as we have to also explore Indian Bar Council. But they have failed in providing an exact definition for professional misconduct because of its wide scope. We can say, though, under Advocates Act 1961, to take disciplinary action, punishments are prescribed when the credibility and reputation of the profession comes under cloud on account of acts of omission and commission by the members of the profession. Now, let us dive into Advocate Act. Section 35 of the Advocate Act, which addresses professional misconduct by Indian attorneys and advocates. If a person is found guilty of professional misconduct, the case will be referred to a disciplinary committee. A hearing date will be set, and the advocate and the Advocate General of the state will be given a show cause notice. After hearing both parties, the State Bar Council's disciplinary commission, we can say the disciplinary committee of the State Bar Council, after being heard of both the parties, can do some of the action. Firstly, It may dismiss the complaint, or where the proceedings were initiated at the instance of the State Bar Council, direct that the proceedings be filed. It may reprimand the advocate. It may suspend the advocate from practice for a certain period. It may deem fit. It may also take drastic steps by removing the name of the advocate from the state roll of advocates. Now, friends, there are multi kind of misconduct. So, expression must be considered broadly to extend the meaning under natural law. It is not justified to limit their natural meaning. The Bar Council of India has the authority to establish guidelines and standards for professional misconduct under Section 49 of the Advocate Act. According to the Act, it is against the Advocates Code of Ethics for anybody to make advertisements or solicitations. He is not permitted to use the name or service for unlawful purposes, demand payment for training, or place advertisements in publications, personal communication, or interviews. Misconduct is broad enough to cover both misfeasance and malfeasance, and it apply to professionals. It also covers unprofessional acts, even if they are not always wrong. Any behavior that has the potential to reflect poorly on the legal profession or damage the positive perception that the public should have of it constitutes professional misconduct. Now, let us explore some of the Supreme Court judgments to clarify the concept further. Firstly, I will discuss State of Punjab versus Ram Singh. Honorable Supreme Court ruled that misconduct can include moral turpitude, must be improper or willful behavior, a forbidden act, a violation of an established and clear rule of action or code of conduct, but not just a mistake of judgment, carelessness, carelessness or negligence in the performance of duty. There is there are a few of the situations which comes into picture when there is professional misconduct, just as contempt of court. So let us dive into this situation. Firstly, what is contempt of court? An offense of being disobedient or disrespectful towards the court or its officers in the form of certain behavior that defies the authority, justice, and dignity of the court. In various cases involving contempt of court, the court held that if any advocate or legal petitioner is found guilty of the act of contempt of court, she may be imprisoned for 6 years and may be suspended from practicing as an advocate. For reference, can go to Binay Chandra Mishra case. The court also held that license of the advocate to practice a legal profession might be cancelled by the Honorable Supreme Court or High Court in the exercise of contempt jurisdiction. There have been numerous additional significant rulings concerning instances of professional misconduct by attorneys. Honorable Court in BC Rangadure versus D. Gopalan examined the issue of professional misconduct in such a way that judgment was rendered in a humane manner, taking the accused future into consideration. Even yet, the court declared justice has a corrective edge, a socially beneficial purpose, especially if the offender is too old to be pardoned and too young to be disbarred. Therefore, given the social environment of the legal profession, a remedial punishment that is not cruel must be administered. The court then rendered a ruling after carefully considering each and every element of the case as well as the parties involved. It established a deterrent style of justice such that the accused individual received certain sanctions but also served as a message to others who could be planning similar crimes. The verdict proved to a turning point in cases involving professional misconduct since it gave a successful verdict without endangering the accused personal future. The court delivered the ruling in a number of other cases too, such as J.S. Yadav versus Mustafa Haji Muhammad Yusuf, in a manner that gave the wrongdoers the impression that offenders will be punished accordingly. So, friends, I am discussing further case law, that is Shambhu Ram Jadhav versus Hanuman Das Khatri. The appellant filed a complaint with the Rajasthan Bar Council, engaged an advocate, alleging that while acting as counsel in the case, the advocate wrote a wrong letter alleging that the judges in question accepts bribes and requested rupee 10,000 to acquire judge's favor. The disciplinary committee declared the advocate to be completely unsuitable to the lawyer after finding the advocates guilty of misconduct. The Rajasthan Bar Council's conclusion that the legal profession is not a trade or business was upheld by the Supreme Court. Members of the profession have a special responsibility to uphold to ensure that justice is carried out legally. It is important to maintain the integrity of the profession and to deter corruption. The advocates' actions were extremely improper because they not only interfered with the administration of justice but also damaged the profession's standing in the eyes of general public. Hence, there is another case, that is Bar Council of Maharashtra versus M.B. Davolkar. The facts under consideration involved advocates positioning themselves at the entrance to the magistrate's courts and rushing toward potential litigants, often leading to an ugly scrimmage to snatch briefs and undercutting of fees. The disciplinary committee of the State Bar Council found such behavior to amount to professional misconduct, but on appeal to the Bar Council of India, it was the Bar Council of India absolved them of all charges of professional misconduct on the ground that the conduct did not contravene Rule 36 of the Standard of the Professional Conduct and Etiquettes, as the rule required solicitation of work from a particular person with respect to a particular case, and this case did not meet all the necessary criteria, and such method of solicitation could not amount to misconduct. This approach of the Bar Council of India was heavily reprimanded by the Honorable Supreme Court. It was held that the restrictive interpretation of the relevant rule by splitting up the text does not imply that conduct of the advocates was warranted or justified. The standard of conduct of advocates flows from the broad canons of ethics and high tone of behavior. It was held that professional ethics cannot be contained in a bar council rule nor in any traditional cant in the books, but in new canons of conscience which will command the members of the calling of justice to obey rules or morality and utility. Misconduct of advocate should thus be understood in the context specific dynamic sense which captures the role of the advocate in the society at large. Now, professional ethics of an advocate. Professional ethics include a moral code that governs how those working in the legal field are and in the practice of law should behave. The court and the administration of justice are two entities to which every member of the legal profession owns a supreme responsibility. In situations where there may be a conflict of duties, this duty takes precedence over all other duties. Legal professions must conduct themselves honorably, help the court in a responsible manner, and foster public trust in the legal system. They are obligated and expected to conduct themselves with decency and integrity when performing their duty toward other lawyers. In addition to being experts in their field, attorneys serve as officials of the court and are essential to the administration of justice. The set of guidelines that govern their professional behavior consequently result from the obligations they have to the court, their clients, their adversaries, and other advocates. Chapter 2, Part 6 of the Bar Council of India rules contains regulations on the professional standards that an advocate must uphold. In accordance with Section 49, Subclause 1C of the Advocate Act of 1961, the rules have been established. Now, the advocate have also duties toward the client. Firstly, he is bound to accept briefs, not withdraw from service, not appear in matters in which he is a witness, full and frank disclosure to the client, uphold the interest of the client, not suppress any material of evidence, not disclose any information about his client and himself, not receive any interest in the actionable claims, not charge depending on the success of matters, keep proper accounts. Now, advocate 2 has duties toward the court. First one is act in a respectable way. An advocate must conduct himself with dignity both during the course of his case and when appearing before the court. He ought to act with respect for himself. The advocate has an obligation to report his complaint to the appropriate authorities whenever there is reason to do so regarding a judicial officer. Second, he should honor the court. The advocate must treat the court with respect. He or she must keep in mind that free community cannot survive without the dignity and respect shown to the judicial officers. No private communication. Advocate should not speak privately with the judicial officer about any case that is currently before the court. The advocate shall not use illegal or unethical means such as threats, bribes, or coercion to affect a court's decision in any manner. Refusal to act in an illegal manner toward the opposition. This is another behavior he should do. An advocate should not behave improperly towards the opposing counsel or party. He must make every attempt to prevent his client from acting improperly, illegally, or unfairly against the court, the opposing counsel, or the other party. A refusal to represent clients who demand to engage in any unethical behavior. I am repeating, a refusal to represent clients who demand to engage in any unethical behavior. When a client insists on utilizing unethical or improper tactics, the advocate must decline to represent them. He must speak with respect when communicating with others and making arguments in court. During the pleadings, he must refrain from slanderously harming the party's reputation. He should appear in an appropriate attire. The advocate must always appear in court while dressed appropriately in accordance with the Bar Council of India rules, and that attire must be presentable. He should not represent the establishment of which he is a member. And advocate is not allowed to testify in court on behalf of or in opposition to any organization of which he is a part. But this rule does not apply to a case of appointment as a amicus curiae or without a fee on behalf of the Bar Council. Now coming to what should be the solution when he has done misconduct. There should be punishment. So I am discussing about punishment for professional and other misconduct. A lawyer's profession is meant to be a divine or secret profession by all means. In every profession, there are certain professional ethics that need to be followed by every person who is into such a profession. But there is the fact that professional misconduct is a common aspect not only in other professions but also in advocacy. So if I say in simple terms, it means certain acts done by a person who seem to be unfit for the profession, as well as which are against certain ethics in this field. As I already discussed, the term has been clearly defined in Black's dictionary. Now, coming to punishment of advocates for misconduct. Where on receipt of the complaint or otherwise, a state bar council has reason to believe that any advocate on its roll has been guilty of professional or other misconduct, it shall refer the case for disposal to its disciplinary committee. Now, firstly, what will happen? The State Bar Council may, either of its own motion or an on the application made to it by any person, withdraw a proceeding pending before its disciplinary committee and direct the inquiry to be made by any other disciplinary committee of that State Bar Council. It has the power. Secondly, this disciplinary committee of a State Bar Council shall fix a date for the hearing of the case and notice thereof to be given to the advocate concerned and to the Advocate General of the state. The disciplinary committee of a State Bar Council, after giving the advocate concerned and the Advocate General an opportunity of being heard, may make any of the following orders. Firstly, it may dismiss the complaint or where the proceedings were initiated at the instance of the State Bar Council, direct that the proceeding be filed. It may reprimand the advocate, suspend the advocate from practice for such period as it may deem fit, remove the name of the advocate from the state roll of advocates. When where the advocate is suspended from practice under clause C of subsection 3, he shall, during the period of suspension, be debarred from practicing in any court or before any authority or person in India. Where any notice is issued to the Advocate General under subsection 2, the Advocate General may appear before the disciplinary committee of the State Bar Council, either in person or through an advocate appearing on his behalf. Disciplinary committee, a person or group of individuals who have the authority to consider matters and proceedings involving the professional misbehavior of an advocate upon a complaint, revision, suo motu, is referred to a disciplinary committee. The primary purpose of the disciplinary committee is to monitor the observation of professional ethics and standards by the members of the Bar Council of India or the Bar Council of any state. Now the question might arise in your mind, constitution of disciplinary committee. Bar Council shall constitute a disciplinary committee as per section 9 of the Advocates Act 1961. This section provides that one or more disciplinary committees are required to be formed, and each of this disciplinary committee shall consist of 3 members. The election of 2 from the 3 members of the disciplinary committee shall be done by the council from the members of the Bar Council of India itself. The third member shall be co-elected by the council outside of the members of the Bar Council, what shall be an advocate and possess qualification as prescribed under Section 3, Subclause 2 of the Advocate Act 1961. This section further states that the senior-most advocate shall be the chairman of the committee. The term of members of this committee shall not be more than 3 years. Coming to power of the disciplinary committee. Section 42 of the Advocate Act provides power of the disciplinary committee. The section states that the disciplinary committee shall have the same power as vested in a civil court as per the Code of Civil Procedure 1908. Now, I am reading out the powers. First one is summoning and enforcing the attendance of any person and examining him on oath, requiring discovery and production of any documents, receiving evidence on affidavit, requisitioning any public record or copy thereof from any court or office, issuing commission for the examination of witnesses or documents, any other matter which may be prescribed. Restricted powers of the disciplinary committee should also, when we are talking about such a lengthy discussion, let us discuss that. The disciplinary committee can exercise these powers only with the prior approval of certain authorities. Attendance of any presiding officer of the court shall be allowed only with the prior approval of the High Court to which such court is subordinate. Attendance of any officer of the Revenue Court shall be allowed only with the prior approval of the state government. Miscellaneous power. Let us discuss those also. The proceedings before the disciplinary committee shall be deemed to be judicial proceeding. The disciplinary committee shall be deemed to a civil court. If the chairman or any member of the disciplinary committee is unavailable on the date fixed for hearing the matter, then the disciplinary committee may, if it think fit, proceed with the hearing and pass necessary order, provided that the order passed shall not be final order. The proceedings and order passed by such a committee shall not be invalid merely because the chairman or all 3 members of the disciplinary committee were not present. Where the final orders cannot be made because of want of majority among the disciplinary committee or is not in accordance with the opinion of the chairman or members of the committee, then such matter or case shall be placed before the chairman of the bar council. If the chairman of the bar council is acting as the chairman of the disciplinary committee, then the case shall be placed before the vice chairman of the bar council. After hearing the case, the chairman shall deliver his opinion, and disciplinary committee shall follow such final order. Regarding situations involving the professional misconduct of the advocates, there has been various landmark judgments. The court in BC, Rangadure versus D. Gopalan, examined the issue of professional misconduct in such a way that the judgment was rendered in a humane manner, taking the accused future into consideration. Even that the court declared justice has a corrective edge, a socially beneficial purpose, especially if the offender is too old to be pardoned and too young to be disbarred. Therefore, given the social environment of the legal profession, a remedial punishment that is not cruel must be administration. So, friends, these were the issues which I have discussed with you. You might have enjoyed. Thank you for listening. Video is not showing my face. Please listen to voice only.